Welcome to this video on how to transition from voluntary privacy governance to statutory compliance by comparing the DPDP Act and rules with the generally accepted privacy principles. We will explore the journey from voluntary privacy practices to mandatory enforcement under the DPDP Act of 2023 and the 2025 rules. This presentation compares India's statutory principles-based privacy framework. The purpose is not to suggest that GAPP replaces the DPDP Act. Instead, GAPP can serve as a governance and implementation model, while the DPDP Act and rules establish legally enforceable obligations. The comparison focuses on practical areas such as notice, consent, purpose limitation, data quality, individual rights, security, third-party processing, retention, accountability, and enforcement. The objectives of this video include understanding GAPP principles, mapping them to DPDP obligations, and designing a practical roadmap for compliance. The key learning outcome is the ability to translate principles into operational controls. For example, the GAPP principle of notice must be implemented under DPDP through clear and accessible notices that explain the data being processed, the purpose, rights, and grievance mechanisms. You should also understand that a privacy program can be broader than the minimum legal requirement. GAPP may encourage governance practices that are not expressly mandated in every situation under DPDP. It is important to distinguish between the two frameworks. GAPP is a voluntary, principle-based model, whereas the DPDP Act provides a mandatory, enforceable framework. GAPP is best understood as a management and assurance framework. It helps an organization structure its privacy policies, procedures, controls, monitoring, and internal accountability. The DPDP Act is law. It defines roles such as data fiduciary, data processor, data principal, and consent manager. It also creates the Data Protection Board of India and allows penalties for non-compliance. The DPDP Act applies to digital personal data processed in India, including data collected in non-digital form and subsequently digitized. It can also apply to processing outside India, connected with offering goods or services to individuals in India. Key terminology includes data principals, data fiduciaries, and data processors. The main difference lies in DPDP's specific focus on digital personal data within India. The DPDP Act uses the term data fiduciary rather than data controller. The data fiduciary remains responsible for compliance even when processing is outsourced to a data processor. The Act does not create a separate statutory category equivalent to GDPR's special categories of personal data. However, additional obligations may apply to significant data fiduciaries based on factors such as the volume and sensitivity of data, risk to individuals, and implications for national security or public order. There are 10 generally accepted privacy principles, ranging from management and notice to security, quality, and monitoring. These 10 principles provide the organizing structure for the comparison. They cover the entire privacy lifecycle, from governance and collection through use, disclosure, security, individual participation, and enforcement. Many of these principles are reflected in the DPDP Act. However, the way they are expressed differs. DPDP gives legal effect to some principles, while others appear indirectly through fiduciary duties, rights, rules, contractual obligations, or security requirements. This crosswalk illustrates that the DPDP Act shows high alignment with these standard global privacy principles across all key areas. The crosswalk shows that DPDP broadly reflects internationally accepted privacy principles. The important distinction is that DPDP does not merely recommend these practices, it creates statutory obligations. The alignment is not always one-to-one. For example, GAPP's quality principle is broad, whereas the DPDP Act specifically requires completeness, accuracy, and consistency when data is likely to be used for a decision affecting the data principal or disclosed to another data fiduciary. Regarding notice and consent, the DPDP Act requires that consent be free, specific, informed, unconditional, and unambiguous. DPDP makes consent a central mechanism for processing personal data. Consent cannot be hidden in a vague privacy policy or bundled with unrelated purposes. The Act also requires that withdrawing consent should be as easy as giving it. A practical implementation would therefore include a visible consent dashboard, granular purpose-level controls, and a direct withdrawal mechanism. The notified rules add operational detail, including a requirement for a separate, understandable notice that provides an itemized description of the data and the purpose of processing. For data collection and retention, the DPDP position emphasizes that processing must be for a lawful purpose, with clear requirements for deletion once that purpose is served. Purpose limitation means that an organization should be able to answer 3 questions. Why is this data being collected? What data is necessary for that purpose? When will the data be deleted? The DPDP Act requires erasure when the specified purpose is no longer being served or when consent is withdrawn, unless retention is required by law. The rules also prescribe retention of certain personal data, traffic data, and processing logs for specified regulatory purposes for a minimum period of 1 year, subject to applicable exceptions. A privacy team should maintain a data inventory, purpose register, retention schedule, and deletion evidence. Under the DPDP Act, individuals have rights to access summaries of their data, request corrections, seek grievance redressal, and nominate others to exercise rights on their behalf. DPDP gives individuals meaningful rights, but the rights are not identical to every right available under GDPR or other comprehensive privacy laws. For example, the DPDP Act does not create a general statutory right to data portability or a broad right to object comparable to GDPR. The right to access is also structured around information such as a summary of personal data, processing activities, and certain sharing details. Organizations should provide a clear request channel, identity verification process, response workflow, and escalation mechanism. Data sharing and the use of processors require valid contracts, with the data fiduciary remaining responsible for compliance throughout the process. Outsourcing does not transfer the data fiduciary's legal responsibility. An organization should therefore conduct processor due diligence and include privacy and security obligations in contracts. A strong processor management program should include a processor register, data flow mapping, security assessment, breach escalation requirements, subcontractor restrictions, deletion obligations, and audit or assurance rights. This is an important area where GAPP's third-party disclosure principle and DPDP's fiduciary accountability work well together. Security measures such as encryption, access controls, and robust incident response procedures are essential to protect personal information. The DPDP Act requires reasonable security safeguards to prevent personal data breaches. The rules provide more operational detail, including controls such as encryption, access control, logging, monitoring, backups, and measures for preventing recurrence. The breach response process should distinguish between detection, containment, assessment, notification, remediation, and post-incident review. Under the notified rules, the first intimation is made without delay, with detailed information submitted to the board within the prescribed period, including the 72-hour requirement described in implementation guidance. Accountability mechanisms include appointing data protection officers, conducting impact assessments, and providing oversight by the Data Protection Board of India. Management is the foundation of an effective privacy program. Policies alone are insufficient unless they are supported by roles, budgets, training, controls, monitoring, and evidence. The DPDP Act imposes enhanced obligations on significant data fiduciaries, including appointment of an India-based data protection officer, an independent data auditor, periodic impact assessments, and audits. Even organizations that are not classified as significant data fiduciaries should consider adopting these practices voluntarily because they demonstrate accountability and improve operational readiness. Special provisions exist for children, sensitive data, and cross-border transfers, requiring enhanced safeguards and risk-based assessments. DPDP takes a distinctive approach to children's data. The statutory definition of a child is under 18, and the Act prohibits tracking, behavioral monitoring, and targeted advertising directed at children, subject to prescribed exceptions. Unlike GDPR and several other frameworks, DPDP does not establish a separate general category of sensitive personal data. Organizations should not interpret this as permission to treat health, biometric, financial, identity, or children's data as ordinary data. Risk-based governance should still apply enhanced safeguards. For cross-border transfers, the DPDP Act permits the central government to restrict transfers to notified countries or territories. To achieve compliance, organizations should prioritize understanding their data, strengthening transparency, operationalizing rights, and building accountability. The key message is to move from documents to operating capability. A privacy notice is useful only if the organization's systems, contracts, and employee practices match what the notice says. The first implementation exercise should usually be a data flow inventory. Once the organization knows what it collects, why it collects it, where it is stored, who receives it, and when it is deleted, it can design the remaining controls more accurately. Consider an online learning platform. It must handle student data, parental consent for minors, and marketing preferences, while ensuring it limits collection to necessary data. The platform's control design includes issuing purpose-specific notices, maintaining breach response procedures, and providing clear channels for data correction and deletion. This example demonstrates how the principles work together. The platform should not treat all data collection as one broad consent. Course delivery, payment processing, learner support, analytics, and marketing should be considered separate purposes. If the platform serves children, it should implement age assurance and parental consent controls, while avoiding prohibited tracking or targeted advertising practices. It should also ensure that teachers, administrators, processors, and marketing teams receive only the data necessary for their functions. Key takeaways emphasize that GAPP provides a structured model, while DPDP converts these principles into legal obligations that organizations must follow. The strongest approach is to combine the two frameworks. Use GAPP to organize the privacy management program, and use the DPDP Act and Rules to identify mandatory Indian legal requirements. A mature privacy program should be demonstrable. The organization should be able to produce its data inventory, notices, consent records, processor contracts, retention schedule, security safeguards, rights request records, training records, audit reports, and breach response evidence. Review your internal processes by asking, are our notices sufficient? Can we demonstrate valid consent? Do our processor contracts meet accountability standards? Use these questions to transition from theory to implementation. Ask participants to identify one immediate improvement in each area: transparency, consent, data lifecycle, rights, security, vendors, and governance. The objective is not to create a separate compliance exercise for every framework. A well-designed privacy management system should allow one set of controls to satisfy DPDP, GAPP, and, where relevant, additional frameworks such as GDPR or sector-specific requirements. If you are interested in trying out the DPDP Act provisions, you can use the Consent Manager simulation portal at myconsentmanager.co.in to test your integrations as a data fiduciary or data principal. We recommend the GAPP Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to comparison of DPDP Act and Rules to GAPP. Hope you now know more about the similarities and differences. This was the 46th video in this series, released by DPDPAmentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, DPDPAmentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.